Because my airing and sharing are infrequent, I combined a number of topics in one video. So let's begin. Characterization is exercised in interstate cases where the courts prioritize one law over another, usually choosing the laws presented by the forum, lex fori, to address a procedural issue and applying the law of the place, lex loci or lex loci in Latin, to address a substantive matter. Here are the main forms of lex, which you will study later. By the way, I don't read my own slides ad verbatim. I just summarize them by adding my notes or arguments. As in all my presentations on this channel and others, I include knowledge that is already familiar or well studied, as well as my own takes, my philosophy, and my ways to connect you with the topic by introducing multiple choice questions and answers that I write, which you cannot find anywhere else except for the last section of this video. Here I define the forms of lex loci, lex causae, and explain lex fori, showing how the Constitution prohibits the states from applying their own statutes extraterritorially and in the meantime allowing the foreign states to exercise comfortable defense and even apply their own laws by analogy. Such refinement of the roles not only shortens the arms of the states, but also diminishes the conflicts of laws as a separate branch of law to be tested by itself. It reminds when in Rome the Pope had the power to prohibit the bishop from enforcing the law of his diocese against foreigners, or the feudal Crete enjoying the power to prevent the court of Paris from applying its own rule on the land, say in Toulouse, Burgundy, or Grenoble. And so, in the gradual process of academic petrification, coupled with shrinking superior orders and ideologies, the conflict of laws doctrine has traded fertile inconsistencies with infertile consistencies, relegating the party's autonomy and the basic lex fori, and bringing the branch of conflicts of law to the edge of extinction. So here we are, resorting to restatements, a secondary source to save the judicial art and craft. I have selected some doctrines of conflicts of law from Restatement Second with my scenarios attached, which you can study later. Among those are inconsistent judgment, equitable relief in the state of rendition, statutes of limitations and borrowing statutes, reversal of the former judgment, witnesses, the place of wrong, and the long arms. Now, about the judicial review, which is relevant not only in terms of resolving interstate or international conflicts of laws, but also for the checks and balances in the federal government. Yet, the judicial power is really intricate to describe in a concise manner. Judicial review is the power or ability of the Supreme Court to declare a legislative or executive act in violation of the Constitution. But the trick is that up until Marbury v. Madison, 1803, you could not find the term judicial review in the U.S. Constitution. Marbury versus Madison adopted the view of Alexander Hamilton from the Federalist Paper 78, whereby the judges have the duty to follow the higher law when it conflicts with an inferior law, like a statute. So it was in Marbury v. Madison when the first time the statute exceeded the powers of Congress, and therefore it was void as being unconstitutional. This established the principle of judicial review through unanimous opinion written by Chief Justice John Marshall. Even when our influencer John Locke identified three heads of government, one legislative, one executive, the third wasn't judicial power. Rather, it was federative power, or the power of foreign affairs. So then, in the 17th century England, judicial power was just considered part of the executive branch, and the judges were agents of the crown. Now, Article 3 of the U.S. Constitution guarantees the judicial power as the third branch of government, and technically it is about the federal courts and justices who hold tenure, which is the guarantee against the lowering of salary while in office or being fired unless impeached or prosecuted. It is hard to shape the boundaries of judicial power, as the duty of judges is not only to interpret laws but also to create precedents, the common law, which in itself is a legislative activity, as common law is also law. So in that sense, the judge acts as a legislator. Then why have three branches? We know that the essence of judicial review is to ascertain the sources of law, such as constitution, statutes, common law norms, stare decisis, acts and regulations, or restatements. Yet not all sources have the same direction over the subject matter. It can happen that a federal district court hears a dispute between states Montana and Alabama and needs to follow one of the state's choice of law rule, or the United States is in lawsuit with Andorra or Finland, for example, and the court must see the body of law that will govern the decision over that international dispute. And if the sources of laws come in conflict, the judge must sort the laws hierarchically to locate the most influential or prevailing law. Can an administrative regulation beat a statute? Can a statute beat the Constitution? Theoretically, no. If an administrative regulation and a statute have different directions, the statute must win. The same is the supremacy of the Constitution upon a statute. It doesn't mean that the statute was wrong or weak. Rather, it happened because the statute was trumped by a higher law, the Constitution, in a specific case. The statute that lost the battle to the Constitution still remains a valid law in the eyes of the Constitution based on Article 1, Section 7 of Constitution titled Legislation. Quite tricky, isn't it? So the judicial review is the recognition by courts that if there is a conflict between the Constitution and any other source of law, the Constitution has to win that conflict. And we do not need a specific clause, let's say a judicial review clause, in the Constitution, as the grant of judicial power already includes it. And that's the essence of judicial review. It is Congress, not the Supreme Court, that constitutes the size of Supreme Court and decides the number of associate justices. Although judicial review is a duty to follow the highest law of the land, following the supreme law is not an act of supremacy. If Congress decides that a particular action is beyond its constitutional powers to enact, it doesn't have to pass a law. And if Congress refuses to pass a law because it's beyond the Article 1 powers, the other two branches don't get a say in that. It is solely the legislative branch's decision. And if Congress decides that a particular action is within its powers, only then will it get passed over the president to decide to sign it into law or to exercise veto power. After, the Congress majority may override the president's veto. Essentially, all three branches must concur that the measure is constitutional before it can be imposed on the people. In other words, Constitution is not the law that governs us, the people. It is the law that governs those who govern us, and who cannot change that supreme law that governs them without the amendment process. Yet we, the people, enjoying our liberties given by the Bill of Rights, can argue or change laws imposed on us without going through the legislative process. Unlike us, officials who are given the power by the Constitution cannot change the text of the Constitution, as they have taken the oath of office to be bound to the supreme law of the land. Judges too cannot change the text or meaning of the Constitution until it is improved by an amendment. And that's what originalism means, which means that the Supreme Court is not sovereign. So, the question: can the U.S. Supreme Court change the U.S. Constitution by the power of judicial review? Has two quick answers. No, it can't, because there is no reference to a power of judicial review in the text of U.S. Constitution. And the said power is implied, not expressed, by two articles of the U.S. Constitution as provided herein, and which present the vesting and supremacy clauses. Chevron Deference has sprung from the Chevron USA v. Natural Resources Defense Council, a 1984 case. This doctrine suggests that in litigation over federal agency action, the courts will defer to the agency's own construction of its operating statute unless that construction is outside the range of reasonableness, usually because the meaning of the statute is clear. The purpose is to give the executive branch considerable leeway in determining the scope of its own power. So basically, the Chevron Deference doctrine says that when the agency's interpretation of the laws that they administer are challenged in federal court, the court isn't supposed to figure out the right answer to the question of statutory interpretation. It's supposed to look for a clear answer, and if there is no clear answer, then to approve the agency decision as long as it's reasonable. Chevron deference has always been a controversial topic, as why would one allocate decision-making authority to agencies rather than courts? The counter is that it could make sense if it was about the interpreting of a statute in an administrative law case, yet it wasn't. Here, the agency uses the words written in the U.S. Code, then articulates it out to have the U.S. Code not function as a federal statute in the sense of creating legal rights and obligations. These rewritten rules are delegations, allowing the agency to go forward and make a policy. And when we end up in a situation where we have to choose between agencies and courts, then the agencies have both the expertise and democratic pedigree that the courts don't have. This raises inquiries into what is behind the intoning the language of statutes, and under the non-delegation doctrine, are those statutes creating law or creating curbside legislators, policymakers? The Associate Justices late Scalia, Gorsuch, and Kavanaugh have been powerful critics of the Chevron deference, describing it as an abdication of the court's Article 3 duty to independently interpret law, and by that aggrandizing the power of the executive branch at the expense of the legislative and judicial branches. You will explore more on this slide. The deep constitutional inquiry is whether fundamental political issues should be debated and resolved by representatives of the people who legislate laws or by the agencies, the executive power. And yet, this is not how a republic works. Conventionally, I conclude with a quiz. You may find time to answer the 12 multiple-choice questions that I have written for you, my subscriber. The answer key is on slide 38. Now, the liberty is yours to re-navigate through the slides in your own space and pace. So long.